Matt Day here with Parsons, Graham & Day, and I've had a number of cases come in and I felt like it was important to talk about this. Relocation, right? In Oklahoma, if you're going to move the primary residence of a minor child that is subject to a court action, right? So we've got a decree, we've got an order in place, and you're wanting to move that child more than 75 miles from where their current primary residence is, you have to provide the proper notice of an intent to relocate, okay? So notice for intention of relocation requires the new address if it is known, the mailing address if it's going to be different from the new address, the phone number if it's going to change, otherwise you just list your current phone number, the date that you're proposing to move, the reasons why you're wanting to move, a proposed new visitation schedule, and a notice to the other party that they have 30 days in which to file an objection to the relocation. That is a proper notice, right? 7 things, and you have to list them out. Before you start writing out your notice to relocate, one of the things we need to consider is, are you the person entitled to determine the primary residence of the minor child? And the question there is, really, if we have a joint custody plan, it's who is the primary physical custodian? With whom does the child primarily or mostly live throughout the year? That person most likely is the person who gets to determine the primary residence of the child. Once we've done that, we go through our 7 requirements for the notice, right? Again, new address, mailing address, phone number, date of anticipated move, reason that we're wanting to move, proposed new visitation schedule, and a notice to the other party that they have 30 days in which to object. All of those have to be put in there. Once that has been put together, you mail it to the last address for the other party. You cannot hand deliver it to them yourselves. That's not good, okay? There's some question as to whether or not certified mail would work. Obviously, everyone's like, well, if I certified mail and they signed for it, right, it's great. I know they got it. The statute requires only that you mail it to their last known address. Another situation I bumped into is where they mailed it to the attorney of record for the person, right? So it's Jane Doe versus Bob Smith, and Jane wants to move the primary residence, and she mails her notice to Bob Smith's attorney rather than actually mailing it directly to Bob, all right? Now, there's some ways to get around that, but the best thing to do is to follow the statute. The statute says mail it to the parent's last address, okay? Whatever their address is, whatever it is of record, that's the one that we should be mailing it to, okay? Once we do that, they've got the 30 days in which to file the objection. If they don't file the objection and there has been proper service, then the move is presumptively okay. That's what the statute allows for, all right? Now, if you don't follow the statute, if you don't follow the law, which, by the way, should be recited within your decree. So there should be a provision in there that spells out the relocation statute. But even if it's not there, it's still the law, okay? If you don't follow it, that can be grounds for changing the physical custody of the child. That can be grounds for denying your request to move later on if it's heard by a court. So when you're thinking about relocating, or when you're confronted with a possible relocation case, take into consideration, do I have the actual authority to move the child? Have I created a sufficient notice, right? Have I objected on time? Okay? Because if we're not following the law, we can have consequences in court, and that's not what we want. For more questions, give us a call at 918-307-1529, or visit us on our website, www.pdtulsalaw.com.